practices on how to file a request for assistance form. I'd now like to introduce who will lead us through this webinar. Lauren, over to you.
Thank you very much, Swati. I hope everyone can hear me okay. Tips and techniques, a webinar for filing a request for assistance. Just by way of background, those people that have been involved in anti-counterfeiting enforcement at the border can identify with my first slide because that's kind of how we all felt. And we've now got the Combating Counterfeit Products Act, affectionately known as the CCPA. There's background noise, by the way. Somebody doesn't have their phone on mute, so I'm getting a lot of feedback. I don't know if anyone else is getting it. So it's important to know that under the new changes, there's prohibitions now on importation and exportation of goods, whether there's a registered trademark, and of course, there's prohibitions for copyrighted works. So now for the first time, we've got Canada Customs officers with the ability to target and detain, and I underscore those two words because we know that that doesn't say destroy, it says target and detain. So this is an additional power to anything that they had or didn't have before. The other thing is that they can share information with us, and this is a really key point when it comes to filling in the form, because the more information that we give them, the more information they're able to give us. And I will go through the fact that we've already had a couple of cases that the CBSA has sent us, and in those two cases we have received information and we have provided information, so we have at least some feedback as to how we think it's working, and of course, a little bit of feedback on how CBSA thinks it's working, which overall, I'm very pleased with the way it's been working, other than the fact that, of course, we would like to have a lot more cases. So you've got to file this form, and this presentation deck will be available, but you should recognize that gray market products, and that you have to, before you get an order for destruction or delivery up, notice must be given to the owner. So those are just a few things that you have to remember when you're dealing with the CCPA. And under trademark, it's very similar. So, to answer a few questions that some of you might ask, when does Customs start detaining suspected counterfeits? Well, they started about 3 or 4 weeks ago. We were contacted on a Vancouver case and a Montreal case, one dealing with a plastic product and one dealing with an apparel product. The procedure that they followed was each of those cases, a request for assistance, an RFA, had been filed by the brand owner. The information on the form was used by Customs, who contacted the two named people on the form. Once the contact was made, in one case, other people were contacted. It's an interesting procedure because I think if most people were like me, I kind of thought that the moment you got the call from Customs, it was an, oh my God, the clock starts ticking, I got 10 days to do something. It doesn't really work that way. They contacted us, and I'll deal with the apparel case. They contacted us and they said, we suspect that we have some apparel that is counterfeit. How would you like to proceed? This is how we want to proceed, words to that effect. We said, can you send us images of the product? And they did. We looked at the images. We sent them to our client because we wanted to have a client verification of goods that we suspected were counterfeit. It was approximately a day or so later that we received a verbal confirmation that it was counterfeit. We said, oh. So we sent that to Customs. Customs said, okay, well, let me put together the information we need. And over a period of a couple of days, we also needed better images of some parts of the product. So within a couple of days, I'm guessing 2 to 3 days, we obtained better images. We were able to confirm that the goods were counterfeit and that the brand was interested in proceeding. Customs then sent a formal document. That is their internal document on a notice of detention. The moment they sent that document, which was approximately, I'm going by memory, it might have been 5 or 6 days or more from when we were first contacted. It might have been 3 or 4 business days or more from when we were first contacted, and now the 10-day time period started. We were also told not to rely on the fact that a request for an extension would automatically be granted. And one of the reasons for that is in both the Vancouver and in the Montreal cases, Customs has not yet had their internal training on how to deal with the RFAs. We're now past that, and I don't know that, well, I know that not everybody has received the training at the Customs level internally, but a lot of people have. So I think they're a little better in terms of knowing what the procedures are, but nonetheless, don't rely on the fact that you're automatically going to get a 10-day extension. You've got to have a reason for doing it. So that's been the procedure. We then negotiated in each case. We attempted to negotiate within the 10 business days, a resolution of each of the cases. In one case, we did resolve it after a 10-day extension and on the 20th day. On the other one, within the 10 days, we instituted a legal action against the importer for whatever reason. As a result of which, it's now either resolved or is about to be resolved. So 2 different results, 2 different procedures, but the same basic procedure followed. Next, CBSA training. Just by way of update, CACN is trying to partner and is partnering with other organizations, including the International Anti-Counterfeiting Coalition, the Canadian Intellectual Property Council, and others who want to be involved in providing training to customs officers. And we're in the process of putting together two things. So one is where we've been asked to put together the training, and I think it's fair to say that CACN has taken the lead in Canada in this area and has buy-in from the other organizations, but it's CACN that has been doing the legwork. And the second part is where we don't have a request for training, but we would like to provide it. And so in that case, for example, we've spoken with the president and other members of the International Anti-Counterfeiting Coalition who regularly conduct customs training in the United States and other countries. And we've got a few initiatives that are going on. One is in Blaine, Washington, and the Canadian side of the border, including Vancouver, and of course we'll invite Prince Rupert. And the idea is to do a joint training between the U.S. and Canadian side, and they're working on that. A similar type of situation in regards to the borders in Ontario with Detroit and in the Buffalo Gateway. As well, we've had interest from Quebec, both in Quebec City and in Montreal, to provide training for law enforcement and customs. Again, it could be Montreal and I think it's the Lacal border, doing something together. The thing is, in Quebec, we've been asked to do the training in French, which we've told them is absolutely no problem. We can do that. And the idea of the training would be a trade show format with some specific training designed to accommodate the requests of customs. What can brands do? Brands can register. They can file an RFA. The only real negative comments I've heard from representatives of customs is, we've got a procedure, why aren't more brands registering? People seem to be afraid of the cost and the hidden costs. I don't know that, I think we know more about the cost now. We know that if you're going to let goods sit at customs, that it can cost, for a large shipment, $120 a day at a suffrage warehouse. We also know that you can bring a proceeding in court to either have the goods partially destroyed and keep samples, or have them moved to another storage. We also know that the importer if it's an importer who does other business, is going to have a problem if they don't comply and if they don't do their duty, because they ultimately are responsible, if the goods are counterfeit, for the cost of storage and the cost of destruction. The issue is who pays initially to customs, and under the legislation, it's the person or brand that filed the RFA. In the two cases that we've been involved in, the brands are not, it's not on the table that the brands are paying the cost of storage or destruction, and in the one case settled, those costs have been paid by the importer through the negotiating process, and I suspect that that will happen more often than not. So ultimately, I think that if we look at the practical effect of filing an RFA, you've got the opportunity to get the importer, and if the to pay. If the importer is a fly-by-nighter, you're not going to be waiting too long before you get those goods destroyed, because you're going to have nobody on the other side, and you're going to proceed with the default proceeding. What are brands doing? I know that there are upwards of 70 brands that have filed RFAs. I think that is a ridiculously low number, and I think it behooves any brand that has complained about the situation in Canada at the border to file their RFAs so that we can show the government when we go back there, when they review this legislation in 2 years, that we've tried. We've done what we could, and notwithstanding that, these are things that could be done better. And if brands don't register, don't be surprised if the government says, you didn't even use the tools we gave you, why should we give you different tools? And I can advise that in other jurisdictions like the EU, where they started with a procedure that did not have a simplified procedure for targeting, detaining, and destroying, they moved to that after it was shown that the other system wasn't work. But in their situation, brands embraced the legislation that was put in. Now, ours might be slightly different, but if we don't embrace it as brands, and if we don't use it, and if we don't at least try, then don't be surprised if this is all we get. And from what I can see from the two cases we've had, in one in particular, in the apparel case, it was not a full shipment just of the brand that filed the RFA. Other brands were probably on that shipment, and other brands on that shipment had probably not filed the RFA, of which customs had pretty much no choice but to release the shipment. And my understanding is part of the delay, whoever just joined, if they could go on mute, thanks. I know that in respect of the apparel, it is highly likely that the other brands had not filed RFAs, and because of that, customs had no choice but to other goods, and that meant they had to take out the goods of the brand we represented, which the good news was, I think it was the largest seizure they've had of apparel in the last 8 or 10 years in Canada, and it was pretty sizable, so they were pretty happy. So that's what brands are doing, and at least some of them, and that's what brands can do. And we've gone through why should you file a request. So let's take a look at the form itself. The form is fairly simple. There's several pages of explanation, but the form itself is really, really simple. And we have found some text in terms of the way we have filed them that in some cases is providing information that customs isn't even going to use now, and in some cases they will use now. But notwithstanding that, I think it's important to have that information there, because even if customs doesn't put together a formal procedure to deal with all of the information you give, ultimately if an officer detains a suspected shipment and they see information in there that helps them, then you're ahead of the game. Just by way of, again, a summary in terms of dealing with some of the misinformation, there is no cost to file a request. The form is online. You can get it. You can identify, once you file it, they have the authority to help. You can discontinue anytime. And And not only can you discontinue, we have already amended, in one case 3 times, we've amended the form that we filed on behalf of the brand because new information came in that they thought was important. The other thing is you can include your training documents, you can include authorized distributors and retailers, and that's something that will ultimately assist in expediting authentic shipments because customs doesn't have to waste their time knowing if your address in a foreign country is importing an authorized source in a foreign country is delivering to an authorized source in Canada. Those aren't shipments that you want them looking at, and you can include that information. You can also include suspected counterfeit and pirated importers. So if you have someone, which many brands do, that has been found to have been dealing in counterfeits or pirated goods in the past, you can put them on what we affectionately call the no-fly list. And by putting that information in, the worst that can happen is nothing, and the best that can happen is customs, if they look at it, knows that that's someone that is highly suspicious and they perhaps should be looking a little more carefully. And I suspect, in one of the 2 cases that we've had with customs, I suspect, based upon the knowledge that I had of the importer, that customs probably had some prior dealings with these entities. And while I can't prove that, it's just knowing the entities involved and knowing that some of them had problems in the past. It certainly was not a surprise that they were one of the ones that they found counterfeit products being imported. Okay, so let's get to the form. Legal name of the rights holder. They want the legal name based upon what's registered at CIPO. So make sure that your registrations are up to date. I know that in respect of the over 50 ones that we have filed, it's been a nice cleanup for a few of the clients we represent because, lo and behold, the information at CIPO wasn't up to date. So it was very quickly rectified. And the fact that you have to match with what's registered at CIPO, and in a few cases that we've had, in the ones that we've registered, we've had our clients go ahead and update their information because there either been an assignment or some other change in address that didn't match the information that was at CIPO. So it was done, and that was something that was done very quickly. The same with the address, country, etc. In terms of the representative for service in Canada, it's whoever you want it to be. And it's funny because in one case, CBSA wanted to know when we had put the information in this form, it wasn't the same as the representative for service contained in CIPO to the registration of the actual trademarks. And so we explained to the officer that this is a different form and this is a different form. So these are the people that you want to be aware that there's a potential counterfeit importation of product bearing your intellectual property. And you want those people to be contacted, and there's 2. And so you have the initial contact and the secondary and alternate. Both are contacted by customs in the cases that we've had. So take advantage. And what we've done here is made sure that customs calls everyone that you want on this form and all the info. So we recommend that you fill out the phone number, fill out the email address, fill out everything, because it's going to increase the chances that someone's not going to be on vacation or someone's going to be away or someone's going to miss it. Section B are some of the fun parts. Trademark and copyright, very often we put both. If you have both, put both. Then you put the trademark or copyright registration number. We put C Schedule A because we prefer to deal with it as a schedule. I think it's easier to amend the form. We're just amending schedules. So our recommendation is put C Schedule A, the trademark or copyright registration number. Then the CIPO number in number 8 is it's the registration number from 7. So 7 and 8 are pretty much the same. Harmonized system code, we have only filled that out once in over 50 forms. because we happen to have them handy. They don't care if you don't have that information yet. That's dealing with the new protocols that are coming into place in Canada, and they want that information. You don't have to include it now. They haven't asked for it. Under bonds, we have always we've always put an X under no. So far, no one's been asked to post a bond. My understanding of the bond issue is if there's a brand who just isn't complying, isn't paying, isn't doing the things that they're supposed to do, then don't be surprised if Customs comes and asks you for a bond. But I think as long as you do what you're supposed to do under the legislation, there's no issue there. And then 12 is what I said before. I put, 11 is provide the name and description of authentic goods, such as product features, packaging, and trademark. We put see attached manual, and we provide the information that we want them to have. Under 12, list known authorized importers permitted to bring these products into Canada. Under number 1, we put see schedule whatever, and we just list them. And that way you can add, subtract without having to change your form all the time. 13, known distributors of illegitimate or suspect goods, same thing, see schedule, and we put in a list. And then the rest is pretty easy because you just have to have it signed, print your name, and put the date. And that's it. And that's how you download the form, and you have the information, and there's about, I can't remember if it's 4 pages or 6 pages of instructions, but it's a very easy form to fill out. So that's my pitch. Any questions?
Yeah, we had a question. I'm sorry, my name's Rodney Harvey.
Yes.
I had a question in regards to once a suspect shipment has been identified, do we notify the importer, the person holding the trademark, do we notify the importer that their shipment has been seized and it's has been identified as some counterfeit product on it? Pretty much, it sounds like we take ownership of that shipment if we have the rights to destroy the product. So my concern is that we notify them that action has been taken and what action did.
Yeah, Rodney, you're asking on behalf of, when you say we, you're asking on behalf of the brand?
On behalf of the brand, yes.
Yeah, okay. The Customs will send the notice of detention to the importer and the exporter. They will have notice of it. Those goods stay with Customs in a bonded warehouse or whatever facility they're in until a court orders them otherwise, or until an agreement is entered into. So while the brand is responsible for the cost of storage and destruction, and it doesn't mean that they get to just say, okay, deliver all the goods to me. The way I believe it works is Customs sends out the formal notice of detention to the importer and exporter.
Okay, thank you.
And the procedure that we followed in the 2 cases we had, and that I think is the proper procedure, is we instantly contacted the importer to say, hey, here's a cease and desist letter, and if you want to resolve this, this is what we need, and if not, these are the consequences. And in both cases, we received an immediate response from the importers.
Okay, thank you.
Okay. Any other questions? Does anybody else have any information on dealing with, I'm only aware of these 2 cases. Are there any other cases that anyone is aware of? Well, if no other questions, then Swati, the ball's in your court.
Well, thank you very much for participating. I just wanted to thank everyone on behalf of CACN and Lauren for taking the lead on presenting this really important topic. A recording of this webinar will be available in the coming days, and if you have any questions, please do reach out to myself or to Lauren. I think, Lauren, your contact information is on an upcoming slide. If you could just maybe put that up there. And my information should be up there as well. Yeah, I think it's
yeah, you should talk about our training sessions.
Absolutely. So CACN does offer extensive training programs. We've already put together several training sessions over the past few years, most recently in January with the CBSA. We do continue to offer this training, and there's some information on your screen that shows provides an overview of the various topics that CACN is prepared to deliver. One having a health and safety aspect. There's also a legislation stream and one case studies. If you are interested in booking a training session with CACN, please do get in touch with me. And again, my contact details are at the bottom of your screen. We are looking to put together a series of training programs that Lauren had mentioned earlier on in this webinar this fall called the CACN Reality Tour. We are in the preliminary stages of planning that, but additional information will be sent out via our newsletter in the coming weeks. If you don't already get our newsletter, please do go to our website at cacn.ca and you can register and subscribe to the newsletter, which comes out once a month. And are there any other questions or comments from anyone in the audience right now before we sign off? No? Okay, so on the screen here, you do have both Lauren's contact information as well as mine. Feel free to touch base with either one of us, and we can help out with anything that may come up. Thanks very much.
I'm happy to answer any further questions anyone has offline if you want to contact me.
Wonderful. Thanks, Lauren, and thank you, everybody. Have a great day.
Yeah, thanks, Lauren.
Thanks, everybody.
Bye.
Thank you.